It's time to talk depositions. In particular, in this video, I'm going to be introducing to you some deposition strategies. That way you'll be prepared to go dominate a deposition and ultimately win your client's case. Welcome to Law Venture. My name is Jarrett Stone. I'm the owner of Stone Firm PLC. And in this video, I am your guide to dominating your next deposition. But before we talk about all things depositions, deposition strategies, and how you can go dominate your next deposition. I just said depositions a whole lot, so I'm hoping the Google algorithm's like, hey, this video is about depositions. If you're watching this video on YouTube right now, then I recommend you do two things. One, obviously hit the like button and subscribe. And two, after you've hit that like button and subscribed, don't watch any more of this video quite yet. Instead, what you need to do is go down in the description here on YouTube and check out the link that'll take you to my free online course about depositions. You see, the video that you're watching right now here on YouTube is an actual lesson inside this online course covering depositions. And did I mention that it's a free online course? I think I mentioned it, but I need to reiterate, it's free content, go get your fix. And the benefit of going over to lawventure.com and checking out the free course is that the description allows me to provide so much more details, allows me to be a little bit more interactive. That way you can really get the true value of the material that I'm presenting in this video. So go check it out, link in the description down below. Okay, so let's get this introductory lesson started. And the best way to get you really introduced and warmed up to depositions is to first ask a very simple question. What is a deposition? If we really boil it down, a deposition is an examination of a witness outside of a courtroom. Because the deposition occurs outside of the courtroom, this means that one, you're not in the courtroom, you're typically in an office setting, or maybe you're on Zoom because it's a virtual deposition. And you're not gonna have your judge, you're not gonna have your jury, you're not gonna have the fans in the stands. Instead, for the most part, in most situations, you're just gonna have the lawyers on the case, you're gonna have the particular witness, and usually a stenographer. I say usually because sometimes you can just bring a video camera and then just swear the witness in front of the video camera, and then that video camera becomes the record, or at least the video footage becomes the record. But in your most traditional sense, you're typically looking at the lawyers on the case, the witness, and the stenographer or court reporter. Boring, am I right? You're probably sitting there going through this deposition online course thinking, I'm going through an online course about depositions. Of course I know what a deposition is. But there's a second part that I really want to touch on and stress, because not only do we have to talk about the basics of basics, but I need to put in context what a deposition truly is for all my trial advocates out there. In particular, depositions are a tool that will help you go win your client's case when used appropriately and correctly. Now, this correctly portion, this is what this online course is all about. We'll flesh out exactly what strategies need to be used during your deposition whenever you're trying to execute any strategies that you prepared for. Don't worry about that. We'll put that off to the back burner for future lessons to address. When it comes to using depositions appropriately, just like any tool, there is a time and a place to basically depose somebody. And so we want to cover in this particular lesson, this introductory lesson, the strategies and the thoughts to consider before you pull the trigger on deposing a particular person. So let's get started by talking about the purpose of this particular tool, because all tools are designed to achieve certain things. A hammer, for example, is designed to hammer nails and remove nails. And in all honesty, that's the extent of my hammer knowledge. We just moved into a house. I'm not very handy, and if you're watching a course right now on hammer knowledge, this isn't it. But with depositions, I can talk all day. So let's continue talking about this particular tool of depositions. It is designed to do three things. First, a deposition is designed for you to ask questions and receive answers in order for you to know what a witness knows. The second purpose is that depositions allow you to preserve the testimony. So as you're learning what the witness knows, the positions of the witness, that allows you to get all of that information, all of that testimony, and it's on the record, because with depositions, all the statements made by that particular witness are sworn to. And by basically pinning down all these facts, chiseling it into stone, this allows you to also better prepare for trial. That takes me to the third purpose. Because depositions allow you to know what the witness knows, all the positions that the witness is going to take, and it allows to put everything down on the record that can potentially be used at trial. The third benefit really is that it allows you to better evaluate the merits of the case. Sounds pretty good, right? Well, while depositions can be great tools to achieve these three purposes, there are some instances when a deposition's cons outweigh the pros, but we'll back burner that for now. I think the best way to get started here is to first talk about when, if at all, your deposition can occur. But before getting into the nitty-gritty, I need to kind of give you a quick disclaimer, which is that I want to talk abstractly here, and I want to be kind of general, and I do want to provide some examples that help make the abstract a little bit more concrete. But the reason why I'm not going to sit here and say this is what you need to do, this is how it's done, is because every case is different. Heck, I have cases that are seemingly the same that require different strategies based on the scenarios. So what I intend on doing, not only with this lesson, but ultimately with this course, is just providing you the options and letting you pick the little gold nuggets from each option. That way you can apply it to your specific case. And that way you can go dominate the deposition if you need to have a deposition at all. But we'll talk about that in this lesson. So let's get started generally discussing when exactly a deposition needs to occur. And generally, that's going to occur after both sides have basically entered the lawsuit, typically after the defendant has answered the lawsuit and has made their presence known, so to speak, and the deposition needs to occur before any type of discovery deadline. Keep in mind that discovery deadline may be set by statute, it may be set by the court, it may be set by Rule 11. You need to make sure that you're not pushing your luck here and trying to get a deposition or any discovery after that discovery deadline. Quick heads up, if you're approaching it, it may be best to either ask the other side to agree to asking the court for an extension or just asking the court for an extension. That way you can conduct discovery during that time and nothing's thrown out because you're past that deadline. Just a quick heads up there. So this little sweet spot between an answer and the discovery deadline, that's your discovery process. And that's probably going to apply to 99% of situations. There are some exceptions where, for example, you can try and have a deposition before lawsuit's even filed. I'll maybe list those exceptions down below in the body of this lesson. Again, if you're on YouTube, go check out the actual lesson itself. That way you can see information like that down below. Anyways, during this discovery process, there's another kind of general timeline that I do want to talk about. That way you can kind of get a sense of how things traditionally go. So I'm speaking generally here, but once both sides have entered the picture, entered the case, presented themselves to the court, so to speak, with their filings, meaning there's typically going to be that petition, there's going to be that answer. Once that's all done, then you're normally off to the races when it comes to discovery. I really recommend that you don't dilly-dally, if people still say that. You don't wait and procrastinate before getting discovery sent out. Instead, do that as soon as possible, and we'll flesh that out, or the reasoning out as we go along here. But in general, the traditional route here is sending the, I'll say, requests for discovery responses, which is my big umbrella to include your interrogatories that you're sending to the other side, your request for production, your potential request for admission, and your request for disclosures. If you don't know what any of those are, I'll leave some definitions down below to help orient you a little bit. And so once those are sent, you're more often than not having to wait 30 days or so in order for the responses to be sent back to you. Fingers crossed the responses are legitimate. You don't have to send like a deficiency letter to the other side or contact and confer with the other side to try and get more information, more production, more, I'll say answers or clarifications and all that. But if everything goes smoothly, or once you are able to get the information that you need, you take all the information from your ROGs, your disclosures, your production, and your admissions. Sorry, I was blanking there. You take all that information and you use that information to help formulate how you want your depositions to be. So again, traditionally, your depositions are going to follow after that request for discovery responses period has, it's not ended, but once you've basically have gone through that process of getting that information. Now let's expand this traditional approach, keeping in mind, I'm saying traditional because a lot of people take this approach. If you're thinking right now, well, this doesn't apply to me, rah, 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 just keep watching. But first we got to lay a little bit of foundation of what most people are doing. You see, most people take the approach of taking these discovery requests and the information that they get from them and then using that to formulate their game plan and strategy, and then ultimately take that deposition. The benefit here with this traditional approach is it allows the attorney to work their way up to the potential cost of the deposition. See, depositions, they're pricey. Whether you're having to pay for a court reporter or you're having to basically acknowledge the fact that you're putting more time, what time is money, into preparing and ultimately taking the deposition, or you're having to do a cost-benefit analysis of how much it's going to cost you to go travel to go take a deposition. Quick side note though, a lot of lawyers are basically taking their handy-dandy camera to a deposition. I've done it before. You swear in the witness without a court reporter, no court reporters there, and then you take the deposition. It's all on camera, and the video footage is the record. In that situation, that may save you the $1,000 plus on how much a court reporter would cost. But the downside there is that if you're going to be drafting a lot of motions or responses, then you can't really cite easily to the record of a deposition that's on video. You see, traditionally, if you hire a court reporter, it's like, okay, page 8, line 3, witness said X, Y, and Z. But with the video, it's like you have to get the court's, the file of the video, then you cite to the timestamp. It's a little bit weird. And so it's something to consider if you're anticipating there to be some motion fighting, and then that may answer your question on whether or not you want to save the money and whether or not you want to have the court reporter show up, give you that traditional transcript. But that's more of a side note. Now, with this traditional approach, it gives you some, I'll say, scalability, because you're sending these paper discovery requests, getting paper discovery responses, so you're not having to pay for a court reporter. In fact, the interrogatory responses you're getting, if there are actual answers on there, are typically going to have a notarized verification on them, to where the witness or the other party is swearing to the accuracy of their statements and answers in the interrogatories. The same oath that they're going to take are in their deposition, which is the same oath that they would be taking at trial. So there's some weight there. And the reason why you're scaling is because drafting your discovery requests on paper and then sending them off is super cheap. Other than the time you're putting into it, which more often than not, isn't really a whole lot of time, because unless this is your first time dealing with your particular case, you may have another case that you can maybe use as a template, or maybe you have an attorney friend who can send you their template, you change some things, you send it off. But even if you are drafting things from scratch, there really isn't nearly as much time that you're investing compared to a deposition. Now, you send it off, you send it by e-service, you send it by email, which is typically free, you wait your 30 days, you get a response. And then with this traditional approach, both sides are able to get a little bit more information to better evaluate their case, the strengths and the weaknesses. And that window between receiving the discovery responses but before a deposition allows both sides to basically try and figure out whether or not the case should reach some type of resolution through settlement. To where it's like, okay, hey, saw the discovery responses. This doesn't look good for your client. This doesn't look good for my client. Maybe we can reach a mutual agreement at this dollar amount if it's a civil case. And that little window allows you to maybe reach that resolution without having to deal with the delay of trying to schedule and ultimately have the deposition, wait for the transcript to come back and all that. And it also, hopefully, if you are able to settle in that period as well, you're able to save on the expenses and the investment that comes with depositions. So this traditional approach allows you to get that information, ease your way into working a little bit harder as the attorney, and potentially having to foot the bill if you're contingency, or having your client foot the bill if they're having to pay hourly. This is why a lot of people default to it, because it's safe. And honestly, this is the easier approach because it doesn't take a lot of strategy. But here at Law Venture, we're all about strategy. So let's deviate a little bit from this traditional approach by talking about a few options. So before talking about the approach that I like to use, let's lay a little bit of foundation. I want you to keep in mind that more often than not, and again, look at your jurisdiction, figure out exactly what the rules are. With these written paper discovery requests that you're sending, your interrogatories, your requests for production, your requests for admissions, and your disclosures, some variation of those, I wouldn't say all of those, but again, depending on your jurisdiction, are going to deal with certain limitations. So know your limits. And the reason why I say this is, let's say your interrogatories by statute are limited to only 25. You can only send 25 interrogatories to the other side. Now, if you take this traditional approach and you send your 25 interrogatories, you get your responses, you get your answers, you don't settle the case during that gap period, and then you go take a deposition, and it turns out, man, I wish I could follow up by sending another interrogatory, but I already burned all my interrogatories. That puts you in a tough situation to where maybe you're having to ask the other side for permission to send another interrogatory, or you're having to ask the court for permission to be able to bump that number up a little bit, and you're having to prove why. That is not a good position to be in. If you're having to ask other people for help, that's not a good thing. And so what I do with that foundation laid is I try and find that sweet spot to where I ask just enough information with these requests where I'm not burning each and every one by hitting the limits initially. And then I take that information, I make sure that my requests are hard hitting to where I get exactly what I want without burning everything. So it's all a matter of efficiency in that situation. Get the information that I need to go take the deposition. Again, if that gap period necessitates me trying to settle the case, I'm always open to trying to settle a case if the situation calls for it. But let's say in this situation we're not able to settle it. Take the information from the limited efficient discovery request, go ahead the deposition. If it turns out that I need to use extra interrogatories, then I go use it. Or if we back up a little bit to the very beginning, let's say I send the discovery requests such as interrogatories, I get the responses back, I realize, okay, I can maybe ask this differently with another discovery request that kind of pivots a little bit, or maybe I want to expand on something else, then send another round of discovery requests where I'm still under my limit, and then go have the deposition. My point here is that you need to strategize and formulate the idea or the game plan of whether or not you want to burn all your requests for production, interrogatories, disclosures, admissions, whatever there are limits on in your jurisdiction up front. Because sometimes it's just not a good idea to do that. And so for me, I typically like to ease my way into it, but I try and maybe limit the requests or the overall discovery that I'm sending to like 2 waves. The reason for that is wave number 1 in Texas, it's a 30-day response time, and sometimes, depending on the case complexity, the other side asks for an extension. I'm not a jerk. More often than not, I will give the extension. So maybe I'm waiting 45 days. So as I'm maybe sending out these discovery requests, I'm also delaying the case and slowing it down and getting closer to that discovery deadline, which makes me nervous. I don't like it. And so I try to be efficient while also not dripping out my discovery request and then having my back against the wall in order to beat that discovery deadline. And the point here really is that with your paper request, your discovery request, your interrogatories, admissions, disclosures, production, all that, you're most likely going to get a very surface level response because, and just think about it, you're sending these requests to their lawyer. The lawyer sees it, they see the request, they hopefully will call up their client and say, hey, you got to answer this. Let's kind of, talk strategy here a little bit. And you're basically going to get filtered answers and responses once those discovery responses come back your way. What do I mean by filtered? Filtered is basically maybe the client is like, well, yeah, this is the answer. And the lawyer's like, whoa, okay, we don't want to say it that way. Instead, let's keep it vague. Let's have a little bit of a massaging that we can maybe work around this response a little bit to where it doesn't sound as bad, and you get something that's not as hard hitting as you would like. And so maybe after you get those responses, it's like, okay, you're massaging this topic, let's talk about something else. Okay, boom, you send another wave. But the point here is most likely there's always going to be some depth left to be desired. And so that's really when the deposition becomes extremely valuable. It's expensive, but it becomes extremely valuable because that filtering process, yeah, it's not nearly as filtered as the discovery request. There's maybe some level of filtering if the opposing counsel has prepared their client to respond a certain way. But at the end of the day, if you're taking somebody's deposition, you're face to face, you're eye to eye, and you're, rattling off these questions, you're getting these answers, it's kind of this conversation going, and that filter that maybe was kind of, I don't know, planned or scripted starts to fade in their back of their mind a little bit. And so you become, you get the answers that you're really looking for through discovery requests. But again, do you really want to get to the deposition point? Do you really want to have the delays? Do you really want to have the expense? So maybe by sending 2 waves up front of discovery requests, you're able to head off not having to take the deposition by getting the case resolved, because your 2 waves allowed you to be general, and then the second wave allows you to be a little bit more hard hitting, and maybe that's what you needed. The point here is strategize on what's going to be best for your particular case. And to determine what's best for your particular case, you're going to need to know the rules of your jurisdiction, because by statute, by court, by any type of agreement, there may be a restriction on how many depositions you can take, how many depositions you can take of a particular person. The general rule is 1 bite at the apple with that one person, so you don't want to blow it. The limit on how long the deposition can be, and obviously if there's a discovery deadline, when exactly the deposition can occur. So quick timeout to talk about discovery deadlines real quick. I need to put in perspective the importance of needing to be diligent with all of this, but in particular with depositions. You need to schedule your deposition well before the discovery deadline is coming and approaching. The reason for that is if you can schedule it far in advance, you are going to save years on your life, because the stress is just going to age you very rapidly. The issue with scheduling a deposition is you're having to get so many different schedules aligned. Your schedule has to match with the opposing counsel, which has to match with the witness or the opposing client, and you also potentially have to match with the stenographer or court reporter, depending on whatever situation you're working with there. There's a lot of schedules that have to line up, and you'll be shocked potentially, or maybe you're in it and you understand it firsthand, to where it's like, okay, we can't get this scheduled until a month and a half out. And if you're already cutting it close with your discovery deadline, that's going to stress you out. You don't want to have to deal with that, especially if it's like, oh, hey, sorry, I'm sick, I have COVID, I can't do it. And it's like, okay, now we have to find another date, and everyone else is like booked up on all those days. You get the point here. It's super stressful, especially if it's like you go and you take this deposition, you get a lot of good information. It's like, man, I really want to send a request for admissions based on this information, or I want to send an interrogatory based on what I just received. So you want to have the additional 30 days to be able to make sure everything is, within that discovery deadline. Keeping in mind, this is one issue with one deposition. Things become amplified if there are multiple depositions that need to be conducted, but you get the point here. Now let's transition just a little bit and let's talk about strategizing for multiple depositions. So if multiple depositions are needed in order to win your client's case, then I really want you to strategize the order and the execution of these depositions. For example, the risk you run and the fear you should be having if you're thinking about your particular case is that if you have deposition number 1 with witness number 1 on one day, and then on another day, let's say day number 2, you're having deposition number 2 with witness number 2. If witness number 2 is more important and critical to your case than witness number 1, do you want to have a deposition with witness number 1 that may showcase the deposition questions in advance for witness number 2, especially if both those witnesses involve the same attorney who's going to be sitting in on the same deposition? For example, and this is the plaintiff's lawyer over here, let's say that your client is suing a corporation, and you first start off by deposing an employee of sorts. And in the employee's deposition, you're coming in hard hitting, you're talking about all these topics, and you're basically trying to prove up your case. And then you turn around, let's say a week later, and then end up deposing the corporate representative for that corporation. Well, if the attorney for that corporation was sitting in and listening to the first deposition number 1 of the employee, well, of course, during that week, that particular defense lawyer in this situation is going to prepare the corporate representative of like, okay, here's all the questions that were asked, here's what that plaintiff's lawyer was touching on, here's probably maybe the best way to frame this, here's how to maybe avoid this. And your deposition number 2 is going to be a whole lot more difficult, and it's not going to be a good thing. You don't want to have difficulty on the more important witness. Not to say you always want to take the most important witness first, but you can schedule and you can strategize in order to make sure that you're limiting any potential issues. For example, there have been plenty of times where I have 3 or 4 depositions in the same day. When you're knocking them out back to back to back to back, there's not a lot of time for that witness to prepare. So if I have deposition number 1 at 9 a.m. and deposition number 2 is at 11 a.m., well, the defense lawyer in that situation isn't going to really have a lot of time to be like, okay, in the last 2 hours, here's exactly what the plaintiff's lawyer asked. Here's maybe how to reframe it and then have that filtering process. There really isn't much practical time for that to be presented and to also stick with that particular witness. In addition, you can always try and reorder things to where it doesn't really make sense of where you're going. So if you're, and I'm just gonna flesh out the employee corporate representative example. If you're dealing with an employee, maybe you talk about more open-ended questions to where it's not really clear exactly what you're trying to prove to the audience, but you know exactly what you're going after. And then you take those examples that you're getting, that you're receiving in that deposition, and then you get the corporate rules from the corporate representative and you apply the employee's examples and you show how those rules weren't followed. Again, that's a particular example to make this whole idea more abstract and flexible for your situation. Take the gold nuggets where you hear them and apply them in your case and go dominate your deposition. Here's another situation that I think is a great example when it comes to strategy. I had a defendant, I'll say, provide 2 expert witnesses in a case. Let's say there's expert witness number 1, expert witness number 2. Expert witness number 1, in their production of what the expert witness number 1 reviewed, had a bit of a smoking gun in that production that I think the defense lawyer overlooked and probably wasn't aware of. And expert witness number 2, honestly, I don't know why they hired expert witness number 2. Nothing was really going to be harmful to my client's case. Nothing really benefited their case. I honestly don't really know the point of expert witness number 2. But the point here is that we have these 2 experts presented. And so in this situation, it was like, I really want to take the deposition of this expert witness number 1 with the smoking gun. But I don't think they're aware of what they ended up producing, because it was a massive amount of files. You go through it, you find it, and it's like, okay, let's go ahead and rock their world with this information. But if I say I only want expert witness number 1's deposition and not expert witness number 2, that may raise an eyebrow or 2 over on the defendant's side, and they may start looking at things a little bit more closely. They may catch the smoking gun. They may prepare expert witness number 1 on how to respond accordingly to that smoking gun. So that's not exactly what I want in that situation. So in that situation, it's like, okay, I'm going to notice both depositions. I can still ask some questions to expert witness number 2 if I need to. And if, it may help the case, it may not. Expert witness number 1, that'll definitely help the case. But what will help the case overall is if I can kind of have this smoke and mirror game a little bit, play chess when they're playing checkers, by noticing it, saying, hey, I want these depositions. And from their perspective, it's like, okay, it's pretty on par. We have these experts. Obviously, they're going to want to depose the experts. Makes sense. And then, of course, when we go and depose expert witness number 1, they had no idea that this particular, I'll say file and document was produced, and we were able to kind of come in guns blazing a little bit, come in hard hitting, which was always a good thing. And then because it was so efficient and effective of a deposition, ended up withdrawing the notice for expert witness number 2 because we didn't really need it in that situation. So that's just another example to consider if you're dealing with experts or other witnesses, to where you want to have maybe a little bit of smoke and mirrors. Again, act in good faith, to where if you're going to have a deposition notice sent out, if the deposition is going to be helpful and beneficial, that's when you want to send the notice out, push come to shove if you need it. But the reason why we went expert witness number 1's deposition first is because that was the main piece we wanted. That was we want to knock the queen off the table real quick. And once we did, it was like, okay, we don't really need to worry about number 2. Quick 2 cents about making things efficient, and just honestly, it's a matter of practicality. When it comes to having multiple depositions that need to be taken, consider the economic effect of stacking depositions to where you have multiple depositions on the same day at the same location, to where you're not having to travel maybe to a different city, a different state, or maybe just to a different part of town. every so often in order to have each and every deposition. Whenever you can have multiple depositions at the same location on the same day, stacking it, that allows your client to save a little bit of money. That also helps speed up the process a little bit more. But again, you got to balance the strategy to where if you want to, I'll say, drip out depositions to where you get some information here so you can use it on a deposition later, then again, that may be worth having to go through the travel expenses and the time delays with that. It's going to depend on your situation, so just use your judgment. Okay, so to sum up this entire lesson that you just watched, the too long didn't watch version, make sure that you're very diligent with your discovery process. That means getting your discovery requests sent out as soon as possible, as soon as practical, I'll also say. And make sure that whenever you are sending out your discovery requests, be mindful of whether or not you want to burn all your requests if there are limits that are provided by agreement, statute, or by the court. And such limits also take me to make sure you know your rules in your jurisdiction and do not cut it close with any type of discovery deadline. Always consider whether or not it's worth trying to reach a resolution before having to deal with the delays and expenses of depositions. But if you are going to go down the road of depositions, be sure to strategize on how to best orchestrate and plan those depositions to where you're not showcasing your hand, you're not burning money, you're being very efficient and very effective. If you have any questions about this, leave those in the comment section down below, just like in YouTube. And the big benefit with watching this video on LawVenture is that within the body of this lesson, you're able to get more information that goes beyond the content of this video. So be sure to check it out. And with all that said, I'll see you in the next lesson.